Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of approx 600 words at the speed of 100 words per minute. So get ready for the dictation. 3, 2, 1 and go. Learned counsel for the petitioner contends that since an application dated 22 April 2016 was made before the respondent bank to accept a demand draft for a sum of rupees 4,65,931 towards outstanding dues and to intimate the petitioner in respect of any other outstanding so that the petitioner may clear the same, but neither any order has been passed on the application nor the bank draft tendered along with the application has been accepted by the bank. It is further submitted that in view of Section 13 Clause 8 of the Act, since the entire outstanding dues have been tendered to the respondent bank, the secured asset is not liable to be sold or transferred and no further step is liable to be taken by the bank in respect of the secured asset. The thrust of the argument of the learned counsel for the petitioner is that since the petitioner had already tendered the total outstanding dues by means of a bank draft, the creditor bank cannot now proceed any further with the sale or transfer of the secured asset, and the liability of the petitioner is to be written off in view of Section 13 Clause 8 of the Act. A bare reading of the aforesaid provision goes to show that requirement is actual tender of the outstanding dues, including all costs, charges and expenses by the debtor to the secured creditor at any time before the date fixed for sale or transfer. It is only when the actual tender is made to the secured creditor before the date fixed for sale or transfer, the provision places a restriction on the right of the secured creditor to proceed with sale or transfer of the secured asset and further prohibits the secured creditor to take any step for transfer or sale of the secured asset. The language of the section is very clear that tender to the secured creditor should be made at any time before the date fixed for sale or transfer. In the case in hand, admittedly, the respondent bank proceeded to auction the secured asset on 30 March 2016 for a sum of rupees 28.5 lakh in favor of Srimati Urmila Dikshit and Srimati Manju Dikshit. The bid offered by the auction purchaser was confirmed by the respondent bank. From the pleadings in the writ petition itself, it is clear that the application made by the petitioner before the respondent bank tendering a sum of rupees 4,65,931 by means of a bank draft was dated 22 April 2016. Admittedly, the application was made much after the auction took place on 30 March 2016. It is also pertinent to note that the petitioner borrower in his application dated 22 April 2016 has referred the bank draft to be dated 13 April 2016, but photocopy of the same filed as Annexure 8 to the writ petition goes to show that it is dated 30th April 2016, which in itself sufficient to indicate that though the application is dated 22 April 2016, but it was submitted to the bank on or after 30th April 2016 when the bank draft was got prepared. Since the tender of the outstanding dues has been made by the petitioner on or after the auction sale of the secured asset held on 30th March 2016, the same does not conform to the conditions prescribed by subsection 8 of the Act that tender should be made at any time before the date fixed for sale or transfer. In view of the fact that since the petitioner tendered the outstanding dues to the respondent bank subsequent to the holding of the auction on 30th March 2016, hence he is disentitled to claim benefit of Section 13 Clause 8 of the Act, and thus the relief prayed for in the writ petition is not liable to be granted. Writ petition accordingly fails and stands dismissed. However, in the facts and circumstances, we do not make any order as to cause. Stop.